Uh, so thinking back to the previous case, in this case, there was an issue with regards to whether the state of California would cover pregnancy-related disabilities under their disability plan. Well, in this case, a very similar issue happens, but instead of a state, um, in the past instance, the state of California, in General Electric v. Gilbert, it's the General Electric company. And so the facts for this case is that General Electric offered its employees a disability plan for things that did not occur because of their employment, so non-occupational hazards. But that plan absolutely did not cover disabilities that stemmed from pregnancy, very similar to the state of California. A group of individuals, primarily female employees, sued, and they claimed that it was a violation of Title II of this, or not Title II, Title VII of the Civil Rights Act of 1964. Remember, Title VII makes it illegal to discriminate in terms of employment on the basis of gender. So the question in this case was this exclusion of pregnancy related benefits stemming from disability violation of Title VII of the Civil Rights Act of 1964. It shouldn't shock you what the argument the court puts forth is. It's a 6-3 decision, and William Rehnquist writes the opinion. Rehnquist being notable for thinking that things like intermediate scrutiny shouldn't exist. And though I think he gets there eventually in regards to intermediate scrutiny, understand this is in the mid-60s or in the mid-70s, and he's not there yet. He has not evolved. So writing for the majority on a 6-3 opinion, he argues that the plan absolutely does not discriminate on the basis of gender because it is not a gender-based restriction. It is a restriction on a class of people. Some women choose not to get pregnant, and therefore pregnancy is not inherently, according to the court, a gender-based distinction. Granted, they disregard the fact that only women can be pregnant, but they focus on the idea that not all women get pregnant, and therefore it is not a gender-based distinction. And therefore, they ruled that this action on the behalf of General Electric is not a violation of Title VII because there exists no discrimination on the basis of gender. They're simply choosing what disabilities not to cover, and the disability they've chosen is not gender-based distinction or a gender-based discrimination because it does not discriminate differently men from women. Justice Brennan writes a dissenting opinion, and he argues that the majority of the court really in a narrow fashion sort of looks at the issue in the case without looking at broader systemic issues. His argument is that at a very technical and tiny level, the majority of the court is right, but they shouldn't decide the case that way. If you looked only at a very technical and tiny level, that's how you ultimately get to justifying things like separate but equal laws. Because separate but equal laws at a very technical and confined level don't run afoul of the 14th Amendment. But this case, very similarly, a pregnancy-based discrimination by its nature isn't, in a strict technical sense, a gender discrimination, but it absolutely is when you consider it in a broader sense, because much of the discrimination that existed in terms of employment was around the idea of pregnancy, and certain women would have to forego pregnancy in order to maintain their job, or when they got pregnant would lose their job. And so pregnancy-based discrimination that we're looking for drastically affects women more than men, is exclusively defined to a characterization of women, and therefore absolutely is gender-based discrimination. So companies can choose what disabilities they wish to cover. In 1976, they absolutely could. That's not the case going forward, as you can see below on my slides. In response, direct response to this case, Congress passes the Pregnancy Discrimination Act of 1978, which prohibited two systematic things. First, it prohibited discrimination on the basis of pregnancy. Simply, you could not discriminate on the basis of pregnancy. And second, it required health insurance to cover pregnant workers. So going forward, there was no question about whether pregnancy-based disabilities would be covered, because pregnant workers were to be covered. And so disabilities that stemmed from pregnancy were no longer really a question under the Pregnancy Act, the Discrimination Act of 1978. That if employers provided health insurance, they had to also have health insurance for their pregnant workers as well. The unfortunate end of that, however, is that both pieces of this law in question get challenged before the court. The second part of the law, the one that requires health insurance to cover pregnant workers, the requirement specifically, what was brought forward in a case in 1983, the challenge to it was brought forward in a case in 1983, and Justice Stevens writes the opinion. Remember, this is the same Justice Stevens that's been very progressive in terms of gender issues, oftentimes being the lone dissent and telling everyone that you're thinking about this in completely the wrong way. He writes the majority opinion and says that requiring companies to provide pregnancy benefits, to provide health benefits to pregnant workers, is a violation of the Equal Protection Clause, because it gives extra benefits to women that men cannot receive. And so the second part of the Pregnancy Discrimination Act of 1978 gets struck down as unconstitutional in 1983. This is just another example of how oftentimes legislatures can be much more progressive and much more protective of rights than courts actually can. The first part of the Pregnancy Discrimination Act of 1978, the one that prohibits discrimination on the basis of pregnancy, is actually what is at issue in the next case that we're going to cover.